Yes, thank you, Your Honor. Your Honor, we're here today for sentencing in the matter of the State of Ohio versus Brenna L. Mettler, case number 24 CR 451. Defendant is present in court today with her attorney, Mr. Jim Matthews. At the last proceeding, Your Honor, which was held on August 28th of this year, defendant pled guilty to one count being possession of heroin, a felony of the fifth degree with a forfeiture specification. Your Honor accepted the plea, ordered that the defendant undergo PSR and a drug and alcohol evaluation. We have read the report. The state is ready to proceed. There is no prior agreement as to sentencing, Your Honor, and from what we understand, the defendant has 2 days of jail time served to date. Thank you.
Thank you. Mr. Matthews, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, thank you. Your Honor, we do have a joint recommendation for community control. As to the specific conditions, we would ask that the court basically just order that Ms. Mettler continue down the path she is currently on. She completed a stay at an inpatient facility, Stella Maris. She's currently living in a sober house, has been complying with all conditions of her Cuyahoga County probation, and by all measures, particularly looking at her pre-sentence report, is doing much better than she has been doing in some time. And we would ask the court allow her to continue to build on that current success, Your Honor. Thank you.
Thank you. Ms. Mettler, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Just that I had 7 months sober 2 days ago.
Congratulations.
Thank you. I'm just trying to, clean up the wreckage of my past and continue doing what I'm doing. I feel like I'm doing really well. I'm very active with AA and the community and sobriety and recovery. So.
When did you finish the treatment and start just residing in the sober living?
I moved to sober living July 23rd, so I almost have 3 months there. I finished aftercare about 3 weeks ago, and I'm currently looking for a job. I did get a job part-time with White Butterfly Project. They do like
what?
White Butterfly Project.
White?
Yeah, they do like the Narcan kits for the community and stuff. So I'm doing part-time work with them and then trying to find something else too.
Okay.
So.
How long can you stay in the sober living residence?
As long as I want. I know Stella's and drug court pay for, I think, up to 6 months. So I know like it's 3 months and then you can get a 3-month extension and then I can pay rent after that. I believe it's around like $400. So I can stay there till whenever.
So the first 6 months you get paid for by?
I believe that, the Adams Board has like a fund that they pay for sober living through Stella Maris.
July 23rd, you said?
Yes. No.
You don't have to. I just make sure you say it. I interrupted you. I want to make sure you say everything you wanted to say. Okay. So what's the status? I mean, I won't go back over it because it's bad, but I usually don't look at a driving record, but your driving record is horrendous. What do you need to do to get your driver's license?
I have a few warrant blocks that I have to pay off, and then I can do that program where I would pay like $50 a month to go towards like the, what is it? Not restitution. Reinstatement fees. And then I can get my driver's license, and I have to have a SR22 bond.
What? SR22? Is that something you're working on?
Yes, because I owe restitution for drug court, so I'm kind of like making sure I pay off like my court stuff first, and then I'll focus on getting my license. Because I don't mind taking the bus or getting lifts since everything's pretty around me in Cleveland.
Okay. All right, Mr. Matthews, anything else?
No, Your Honor.
Yes, thank you, Your Honor. The defendant does seem to be doing well by all accounts in her current program. We do support her continuing to do that and to complete that program at minimum. In short, Your Honor, we do recommend probation. Thank you.
I reviewed the pre-sentence report and investigation, drug and alcohol evaluation, consider the facts and circumstances of the offense involved. Nature of the offense. I've considered what's been said here today in court by Mr. Matthews, the defendant herself, the prosecutor, the joint recommendation. All of this, bless you, all of this is considered in light of purposes and principles of felony sentencing set forth in 292911 of the revised code. As for factors in 292912, factors indicating the conduct is more or less serious. Nothing stands out factually about the case which would indicate it's any more or less serious than the normal possession charges that we deal with. As for recidivism factors, the court finds the defendant does have a history of criminal convictions. Also has a history of not responding favorably in the past to previously imposed sanctions. There are multiple probation violations, drug court violations, warrants for failing to appear on other cases in which he's been put on probation, even rather recent. Drug abuse problem that relates to the offense. Can't say now that the defendant doesn't recognize it or doing anything about it. She's taken some major steps to address that, and she appears at the time to be doing well. So I can't make that finding, except for the fact that there is a serious drug abuse offense, obviously. Was on bond for multiple cases in Cuyahoga at the time she committed this offense. Factors indicating recidivism is less likely. The court notes the defendant does appear to have and show genuine remorse and has taken steps here as of recent to serious steps to address the issues that she has and appears to be doing well. And I find that is a factor that indicates recidivism could be less likely at this point. Under 2913B1, the court finds the defendant was released on bond on at least a couple Cuyahoga County Common Pleas cases at the time she committed the offense. That overrides any presumption for community control. However, the court finds at this point prison would not be consistent with the purposes and principles of sentencing, and the defendant is amenable to an available community control sanction. So I'm going to put you on community control sanctions for a period of 2 years. I'm going to order that you serve 2 days in jail. You have 2 days of credit, so there will be no more jail time at this point. I'm going to order that you do not use any drugs or alcohol, that you submit random urine screens when requested. They have to be negative. A positive screen for any drug, including marijuana, would be a violation. You're to attend a minimum of 3 AA meetings a week and have a sponsor. Follow the recommendations from the Cuyahoga County Recovery Court program. Continue your mental health counseling. I want you to reside at the sober living facility for at least 4 more months. Stay longer if you like, that's fine, but I'll make a condition of probation that you stay for at least 4 more months. You only have one doctor and one dentist that could prescribe you medication. If you have a specialist, that's fine too, but anyone that gives you prescriptions for medicine, you need to let who those doctors are known to the probation department. You can only get them from those doctors. You can only get one pharmacy where you get them filled. They need to know where that is. Sign whatever releases they need so they can contact these folks if necessary. Take any medications as prescribed. I'm going to order the forfeiture of the contraband and instrumentalities. I want you to obtain full-time employment or education or some type of training. If you want to go to school and get some type of, get a degree, get certification, something, whatever, you can do that too. But full-time, keeping yourself busy, working or going to school. I'm also going to order that you do not drive a vehicle. I'm not suspending your license. But you're not to drive a vehicle without a valid license. You get a valid license, you can drive a vehicle. So I'm not suspending it, but I'm making sure that if you drive without a license, it's going to be a condition. It's going to be a violation of your probation.
Okay.
You got to get that taken care of. Oh, I want you to be. I know you mentioned it. I want you to also be assessed for EMDR therapy and follow whatever recommendations come out of that assessment.
Okay.
Megan, is there anything else that I should be considering here or thinking about?
No, Your Honor, thank you.
So do you understand all the conditions of your probation, Ms. Bentler?
Yes, Your Honor.
Any questions for me?
No.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while you're on probation, a motion to terminate your community control sanctions will be filed with the court. And if it's found that you did violate, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 12 months on count 1, which could be served consecutive to any other sentence you may be serving at that time or that gets imposed at that time.
Okay.
All right.
Your Honor, I do have one question. Is there any way I could have my Cuyahoga County Drug Court probation officer be the reporting officer?
Not at this point. I'm having
I just wanted
Lake
to
County
ask.
supervisor at this point.
That's
I
fine.
mean, whatever terms that they believe are good for reporting and stuff, I'll let that be with them, but we're going to supervise along with that. All right, Mr. Matthews, anything else for the record?
No, Your Honor, thank you.
Mr. Savace?
Thank you, Your Honor. No.
All right, thank you.
now, can't you?
Yep,
You hear me real well?
yep.
You can hear everything I'm saying right now, correct?
Yes.
No problem? Clear? All right,
Yep.
good. Judge will be out in a second, all right? You should be able to hear everything going on today, okay? Ready to go?
Yes, sir.
All right. All rise. You may be seated.
Ms. Gunter?
Thank you, Your Honor. We're here this afternoon in the state of Ohio versus Marvin Martin, case number 24 CR 557. The defendant is present in open court with his attorney, Mr. Watson. We were last before you on August 28th of 2024. At that time, the defendant did enter a plea of guilty to count 1, trafficking in cocaine, a felony of the 5th degree, with the attached forfeiture specification. At the appropriate time, we would ask that count 2 be dismissed. Your Honor ordered a pre-sentence report and a drug and alcohol evaluation. Those have not been completed on this date. We are here today for sentencing, and the defendant has 12 days of jail time credit.
12.
Correct.
Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court, I'll be extremely brief. My client did plead guilty. He did take responsibility for his actions. This is not an excuse, Your Honor, but the long and short of it is my client is a drug addict, and to support his habit, if you will, he sold small amounts of crack cocaine for money. Your Honor, he pled guilty in this case. He was well aware of what needed to happen, which is to show up to the probation department and to complete the requested assessments. He failed to do so. I've explained to my client this morning, I have had no contact with him, by the way, since the change of plea. I did try to reach out to him. The probation department was kind enough to contact me when he missed his appointment to find out if I knew where he was at. But I did explain to my client that the court's position and by law is that he's looking at prison time. You know, he understands that, Your Honor. If the court will afford him a brief opportunity to speak, he's going to explain that he had some serious problems with his living arrangements. I know that that's not an excuse, and that may not change what may happen this afternoon, Your Honor. I'm going to respectfully request that the court consider a minimum sentence in this case. Again, he has taken responsibility. He is here today. It's my understanding, I just learned this right before the hearing, that he actually turned himself in this morning at the Lake County Sheriff's Office. So he did voluntarily turn himself in, Your Honor. I'm going to ask the court to take those factors into consideration. Thank you, Your Honor.
Thank you. Mr. Martin, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
I'd just like to say I apologize to the court. I ain't got no excuses. I did this to myself. My living situation ain't been stable. I have a lot of documents to bring back to the probation department, and I just missed it. But I was going to show up for sentencing no matter what.
Is there anything else you want to say?
That's basically it, Your Honor.
All right, thank you. Mr. Watts, anything else on behalf of the defense?
No, Your Honor.
Ms. Contra for the State of Ohio.
Thank you, Your Honor. At this time, the defendant did not comply with the conditions of his bond. He did test positive on the day of the change of plea for cocaine. At that time, his bond was revoked and there was a warrant out for his arrest. He did turn himself in this morning, but at this time, we still have no pre-sentence report. The court does advise him of that at the change of plea. And in reviewing his record, he has been to prison on at least 2 occasions in 2001 and 2008. So at this time, the state is in a position where they feel that prison is an appropriate recommendation.
Thank you. We reviewed the pre-sentence report. Well, I did not review the pre-sentence report. I referred the defendant for a pre-sentence report, what I meant to say. Defendant failed to appear probation department for his interview to complete that report. He also failed to appear for his drug and alcohol evaluation, so that report wasn't able to be completed. I have considered the facts and circumstances of the offense as they were related to me at the time of the plea. Nothing stands out factually about what happened here in regards to the trafficking charge, which makes it any more or less serious than what normally constitutes the commission of these offenses. As for recidivism factors, the defendant has a lengthy history of criminal convictions. It goes back 40 years. Juvenile delinquency adjudications in 1984, and then starts as a criminal convictions once he became an adult. He has previously served multiple prison terms. I see at least 3 terms. He's been on probation before. He's violated conditions of his probation in the past, so he has failed to comply with previously imposed sanctions. There's no genuine remorse. Claims there's a drug abuse problem that relates to the offense. I don't know that because I wasn't able to get a pre-sentence report. But he hasn't done anything to address any drug abuse problem. He tested positive while he was out on bond, which is a violation of his bond. Again, he failed to appear at the probation department for any of his assessments. Those are all factors indicating recidivism is more likely. Nothing makes it less likely. The 2913B1, the defendant has previously served a prison term. Prison is consistent with the purposes and principles of sentencing. The defendant is not amenable to any available community control sanctions. There is no pre-sentence report that was completed. Defendant violated his bond. Therefore, it will be the sentence of this court. Defendant served a term in prison of 9 months. He'll get credit for 12 days he's already served. I need to advise you, upon your release, you may be placed on post-release control for up to 2 years. If you are and you're violating any of those conditions, the parole authority can send you back to prison as punishment for violating their rules for another 4.5 months, the maximum being 50% of what I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Defendant's ordered to pay all costs incurred in this action. I'll order the forfeiture of the contraband and instrumentality set forth in the specification. And the court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. I believe that covers everything. Ms. Contour, is there anything else?
Your Honor, if you would just address the balance of the indictment, and then with regards to his bond, I am unsure if it was forfeited when the judgment entry came out with regards to revoking his bond when he tested positive. So I would just ask the court to address that.
I turn himself in. I will not release bond, and count 2 will be dismissed.
Thank you.
Mr. Watson, anything else?
No, Your Honor.
All right, thank you.
All rise.
We're here in the case of State of Ohio versus Diamante Harris, case number 24 CR 473. Excuse me. Defendant is present, represented by defense counsel John Fatika. A previous date in this court, the defendant pled guilty to count 1, having weapons under disability, a felony of the 3rd degree, with an agreement to forfeit all the firearms confiscated. There were 2 of them in this case. Since then, a pre-sentence report has been completed, and we are here today for the sentencing in the matter.
Thank you. Mr. Fatika, any reason not to go forward with sentencing?
No, Your Honor.
Is there anything you care to say on behalf of your client?
Oh, yes. Good afternoon, Your Honor. I've had an opportunity to review the PSR. I'd like to highlight the fact that while acknowledging that Mr. Harris does have 2019 juvenile court adjudication, he did successfully complete probation in that case, was cooperative. This case started as a traffic stop. He was cooperative with the officers, let them know that there were firearms in the car. He mistakenly thought that the juvenile court adjudication had been sealed or expunged. It has been now, but at that time it wasn't. He understands now that he's not permitted to have firearms, and this is a mistake that I don't anticipate that he'll make again. He graduated from high school in 2023, has a fairly persistent history of employment, restaurant-type jobs. He has another job lined up at a restaurant in Willoughby this week. Lives with his mother and 3 younger siblings in Cleveland. She's in the back of the courtroom, is very supportive. We'd ask the court to consider community control sanctions here. Again, he was forthcoming with the officers, but he acknowledges that he made a mistake.
Thank you. Mr. Harris, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yes, Your Honor. I would like to apologize for my mistakes. At the time, I didn't know that I weren't allowed to have firearms. I took the proper steps too, but I didn't know that the juvenile stuff was still there. To my knowledge, I was told that it was gone, but it wasn't. So when the officers told me that it was still active and they wanted to prosecute, it kind of I would say it hurt because I thought I was doing everything right. But I know it's a mistake now. I'm sorry.
Take your time.
I take full responsibility of it now. I know now that I shouldn't have had it, and it was an honest mistake. I didn't mean to fill out the carry conceal form wrongfully. I thought I was filling it out truthfully, and it won't happen again.
Anything else on behalf of the defense?
No, thank you, Your Honor.
For the state of Ohio.
After reviewing everything in this case, the state's recommending community control sanctions. Thank you.
Mr. Harris, why don't you have your license, your driver's license?
I never got one. That's one thing that I'm on the road to working towards now. I owe a fee, a balance on them. It was at $600. Now it's at $300 because I've been paying it off monthly. So I'm trying to get.
So what's this fee for that you owe?
I believe it's court costs or a fine or something like that.
Because of the DUS, the driving under suspensions that you have?
Yeah.
So you never even took the test or applied for the test when you were
no.
16, 18, anytime?
Yeah, no.
Didn't stop you from driving, though.
Yeah.
Well, you get your license, it's going to make life a lot easier for you.
Definitely.
job that you got?
I have an interview tomorrow at Raising Cane's out in Willoughby.
Was it the new one?
I think so, yeah.
What happened at Drug Mart?
I tried it out and it wasn't just kind of my thing. I normally come from like a fast food type thing. Like I've been with Five Guys for like 5 years, so I tried it out and I just didn't like it. So I just wanted to
What
go
were you
back to
doing
fast
there?
food. At Five Guys, I was a crew leader, so I was just
No, I'm sorry, at Drug Mart. What you didn't
like
like?
stocking and cashier, like mostly like medicine and stuff like that.
Did you have an interview tomorrow at Cane's?
Yeah,
Raising Cane's?
yeah.
Put you on probation, you're not gonna be able to smoke marijuana. You know that?
Yeah.
You're gonna be able to, I mean, you haven't, once this case started, you stopped and you tested negative, so demonstrated that you can do that, not use. You can be able to do that for the period of time?
Yes, Your Honor.
Not gonna screw around, bring fake urine samples in or anything like that?
No, Your Honor.
Well, I've reviewed the pre-sentence report investigation, considered the facts and circumstances of the offense involved, the nature of the offense, considered everything said here in court by the defendant, his lawyer, the prosecutor's recommendation. All this is considered in light of the purposes and principles of felony sentencing set forth. In 2911 of the revised code. Factors in 29-29-12. Nothing stands out factually about the case indicating to the court it makes it any more or less serious than what normally constitutes the commission of this offense. So I will note that the underlying disability is based on a juvenile delinquency adjudication. Now, serious adjudication, but a juvenile adjudication, which to me makes it less serious. Still a crime, but not as serious as we normally deal with. As for recidivism factors, the defendant does have the one prior adjudication in juvenile court. He's had no convictions as an adult under the factors indicating recidivism is less likely. Appears to be genuine remorse from the beginning. He's cooperated with the police. Told him about the guns. Offender committed the offense while in possession of a firearm. That's a factor under 29-29-13B1. Court finds, however, that prison is not consistent at this point with the purposes and principles of sentencing, and the defendant's amenable to an available community control sanction. So I'm going to place the defendant on community control sanctions for a period of 2 years. In order they serve 4 days in jail, he has 4 days of credit. You're to use no drugs or alcohol. You're to submit random urine screens. They have to be negative. A positive screen's a violation. It means you can't use marijuana either. And it means you, not even if you can't get a medical marijuana card. Everyone thinks they can get these cards and still use them to smoke while they're on probation, or to get, not even smoke, use them in any manner. Can't do it. You have to submit random urine screens. They have to be negative. A positive screen's a violation. If you screw around with your urine sample, bringing fake urine, someone else's urine, that's even worse to me than testing positive for marijuana. I want you to obtain and maintain full-time employment or education. If you want to go to school, college, or go to some type of training, get certified in something, you can do that as well. But on a full-time basis, you're working, you're going to school, or some combination of those two that you're keeping yourself busy 40 hours a week. All right?
Yes, Your Honor.
If this interview doesn't work out tomorrow, you need to get right back at it and get a job.
Yes, Your Honor.
We still do decision points, Nicole? Yes, sir. I want you to complete the decision points program. Probation will explain that, but it's basically a thinking for a change type of program, help you make good decisions. I want you to complete that program through probation department. Over 2 years on probation, I want you to complete 50 hours of community service. So don't wait to the very end. So it's going to it'll be overwhelming. Do a little bit here, a little bit there, and then that won't be hard to do at all, 50 hours.
Yes, Your Honor.
Pay court costs and supervision fees. I'm going to forfeit the contraband and instrumentalities that are part of the specification. Mr. Randazzo, anything else I should think about here?
Would you like to include obtained driver's license?
I'm going to do two things. Well, you make a reasonable effort to obtain your driver's license, get that. But you are also not to drive a vehicle without a valid license. So if you get caught driving, I don't care if you get charged with if you got convicted, that'd be a violation of your probation. But if you don't get convicted, then technically you would be violating, but you are violating for driving. I'm not suspending your license, so that's not going to stand in the way of you getting your license. But you're not to drive without a valid license except to get your test. If you're going to be taking the test, you need to drive for that. Whatever you need to do to get the test, you can drive for that, but otherwise no driving
Yes, Your Honor.
without a license. Thank you. Do you understand all the conditions of your community control?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another offense while you're on probation, a motion to terminate your community control sanctions will be filed. And if it's found that you violated, I could extend your probation up to 5 years, I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 36 months in prison. So that's what's hanging over your head, 3 years. You understand that?
Yes, Your Honor.
All right. I will dismiss the remaining counts of the indictment as well at this time pursuant to the agreement, and bond is hereby released. Mr. Fatika, anything else for the record?
No, thank you, Your Honor.
Ms. Zagretsky?
No, Your Honor. Thank you.
All right, thank you. Good
All
luck.
right, thank you.
Yes, Your Honor, we're here for sentencing in the matter of the state of Ohio versus Mr. Keith Wall. Case number 24-CR-303. Defendant is present in court today with his attorney, Mr. John Dowell. At the last proceeding, which was held on August 28th of this year, defendant pled guilty to 2 counts, that being possession of cocaine, a felony of the 4th degree, as well as aggravated possession of drugs, a felony of the 3rd degree, plus a forfeiture specification. Your Honor, accepted the plea in order that the defendant undergo a PSR as well as a drug and alcohol evaluation. The state has reviewed those reports. We are prepared for sentencing. There is no prior agreement as to sentencing. It should be noted that the defendant has apparently 21 days of jail time served to date. Thank you.
Thank you. Mr. Dahl, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Briefly, Your Honor, I did have an opportunity to review both the pre-sentence report as well as the Lake Geauga NeoCap report. They both appear to be accurate in their contents. I also filed a sentencing memorandum with this court last week and attached some letters from Mr. Wall's wife, his pastor association, and also his employer. So I'd ask that those be incorporated into my arguments today.
We'll do that.
Thank you. Your Honor, Mr. Wall is 41 years old. We've discussed his criminal history. We know it's significant and ongoing and has been for a long time. What I would like to highlight today, though, is this case was from a traffic stop. He was coming home from taking his wife to work when he was stopped and the drugs were eventually located. There was no indications of trafficking. This was charged as possession. And in my conversations with Mr. Wall, it's very, very clear that he's a drug addict. He works in the restaurant industry as a sous chef. He works a significant amount of hours and high intensity situations. This is absolutely no excuse for his behavior, but it is the explanation that we can give to the court to why he was using stimulants. Most of what he's admitted to using are drugs that keep him moving, keep him running. He has a family, Your Honor. He's does have a significant amount of people here today in support of him who will help him in this process. Your Honor, he's been in jail for 21 days now. He was remanded at his pre-sentence report for testing positive for cocaine and marijuana. I saw him in the jail last week, and honestly, he's a much different person than all my other conversations with him, because I think it's the first time he's ever been sober in a long time. He was able to gather his thoughts and have a conversation with me about what he wants, what he needs, and things of that nature. I think, he's got a newer wife and a young child, as well as 3 stepchildren that are currently living in the home with him. He knows this lifestyle is not one that can maintain. It's not one that's going to lead to success. It's one that's going to lead to his incarceration and take him away from his family, take him away from providing, and take him away from being a father, I think, which is the most important thing to him. Your Honor, the easiest thing to do here is to impose a prison term and be done with Mr. Wall. It's an easy thing to do with his criminal history and the levels of offenses. I think the purposes and principles of felony sentencing, though, would be better met by he was accepted to the NeoCap program. I've had clients, and I know you've had many, many defendants go through it. I think it's an excellent program with great success rates. I'd ask the court to consider placing him in that program, allowing him to complete it and show to this court that he's capable of being a sober and productive member of the community, of being a good father, a good husband, good employee. There's a lot of jail time here, or prison time, I'm sorry, that the court can impose. If Mr. Wall, were to be unsuccessful at NeoCap or be successful but then go back to his other lifestyle, the court could immediately send him to prison for a significant amount of time. I'd ask the court to take that first step, though, and impose a community control sanction with the NeoCap program. It'll be a significant amount of incarceration by the time he would be completed, and it would give him the tools that he needs to do those things that I mentioned. Your Honor, for those reasons, I'd ask the court to impose a community control with NeoCap and hold every day of prison over his head should he be unsuccessful, Your Honor. Thank you.
Thank you. Mr. Wall, you have the right to address the court before you are sentenced. You can say anything you like. Is there anything you want to say at this time?
Yes, sir.
Go ahead.
I'd like to start off by saying I haven't been this clear-headed in a long time. And I use this time to go over my thought process and how flawed it's actually been. It's no one's fault I'm here but myself. I'm accepting full responsibility for the situation I let my addiction put me in, which is taking me away from my family and putting my career in jeopardy. For a long time, I used the excuse of being a chef to justify my addiction, but it's just an excuse. I'm 41 years old, and it's way past time for me to turn the corner and start living like a productive person, as my wife has been trying to encourage me to do for the last 3 years. And I'm asking the court for a chance to prove to myself as well as my family that I'm ready to be that productive person.
Thank you. Mr. Dowell, anything else you want to present on behalf of your client?
No, Your Honor, other than the arguments made today and those set forth in my sentencing memorandum. Thank you.
Thank you. The State of Ohio, Mr. Tavanche.
Yes, thank you, Your Honor. Your Honor, defendant has a storied, long-standing, and varied criminal history spanning some 25 years, a variety of misdemeanors, a string of misdemeanors, a variety of felonies, a string of felonies. As a juvenile, he was adjudicated delinquent for 2 felonies. As an adult, 6 felonies, some of them serious. He's been to prison twice. We're not even sure whether there might not be something else out there. At some point, he was using an alias, someone else's name. A lot of his history indicates a propensity for violence, especially domestic violence. In addition to that, he has a string of failure to appear incidents and PVs, Your Honor. I wonder why this case would have been the one that sort of maybe turned him around. I just have to ask that question, Your Honor. I don't know the answer to that. As far as the instant matter, for this violation, there was a 9-month-old baby in the car with the defendant. I would add also that when he was transported to jail, he was found to have drugs on his person. He's being sentenced for that in terms of possession. He really could have been and perhaps should have been charged for conveyance. That was not done. It was a judgment call, Your Honor. As Your Honor knows, his bond has been revoked for testing positive on the day of his plea. He tested positive for cocaine the first time. Later on, he tested positive for some other substances, that being the date that he was actually arrested. Shortly after the violation, in this case, Your Honor, he's picked up again for OVI, driving over marked lanes, the same thing that he was doing on the night of this incident. Also having an open container, again, what we saw in this incident. This just seems like this case seems just like a part of defendant's longstanding and consistent either unwillingness or inability to conform himself to what the law would require of us. For that reason, we believe that CCS would be inappropriate, Your Honor. Thank you.
Thank you. This court has reviewed the pre-sentence report and investigation, drug and alcohol evaluation, reviewed and considered considered the sentencing memorandum that was filed by Mr. Dahl on behalf of his client, read the letters that were attached to that. I've considered everything that's been said here in open court by Mr. Wald, his attorney, the prosecutor. All of this is being considered by the court in light of the purposes and principles of felony sentencing set forth in 29:29:11 of the revised code. As for the factors in 29:29:12, factors indicating the conduct is more or less serious, the court does note that the defendant did have a 9-month-old child in the vehicle with him at the time he was committing this offense and in possession of all these drugs. He had a very young child with him. That makes it more serious. Nothing makes it less serious. As for recidivism factors, almost all of these factors are present. Has a lengthy history of criminal convictions and juvenile delinquency adjudications going back 25 years. Pretty consistent throughout that time period. He was on bond, Cuyahoga County Common Pleas Court, for a felony offense that ultimately resulted in a misdemeanor conviction, but he's on bond at the time for a felony charge through Cuyahoga County Court when he committed this offense. He has not responded favorably in the past to previously imposed sanctions. I believe the probation officer noted this, but every time he's been on probation, he's violated. There's not a time that he was given probation that he didn't violate his probation. So he has failed to comply with previously imposed sanctions ordered by courts. There's a drug abuse problem that obviously relates to the offense, and the defendant doesn't acknowledge the extent of it. In fact, he told probation, not just probation, but also then during his drug and alcohol evaluation, 2 separate times. The last time he used cocaine was 6 months ago. Told probation was the day of this incident. Told the drug and alcohol evaluator it was 6 months ago. Yet he tested positive for cocaine, not only after he showed up for his referral, but then when he came back a couple weeks later and dropped the screen, that was positive for cocaine as well. So he's not being open and honest about that. And he's still using. Been arrested for an OVI offense while on bond in this case. Didn't show up for his court hearing for that. So there's a warrant out for him for that because he didn't show up to court. He's got 5 warrants out for him right now for all failure to appear for different cases. 5 different courts. Doesn't go to court. Violate the conditions of his bond and using drugs while on bond. There's no factors indicating recidivism is less likely. Count 2 is subject to a presumption for prison. And I don't know how this court can make the finding that the factors indicating recidivism is less likely outweigh the factors indicating recidivism is more likely. I can't make that finding. Prison is consistent with the purposes and principles of sentencing. Defendant's not amenable to any available community control sanctions. There's just no way the court can make the finding to overcome the presumption in this case. Therefore, it'll be the sentence of this court. And count 1, defendant served a term in prison of 12 months. On count 2, he served a term in prison of 18 months. I'll run those concurrent for an 18-month prison term altogether. He has 21 days of credit. I need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. I'm going to order the forfeiture of any contraband and instrumentalities that are set forth in the specification. A mandatory fine of at least $5,000 is required to be imposed, and I'll impose the minimum mandatory fine of $5,000. Costs. Count 3 will be dismissed. And I am releasing bond that was posted. Bond's not being forfeited in this matter. Mr. Devanshi, anything else for the record?
Nothing from the state, Your Honor.
Mr. Dowell.
No, Your Honor.
Thank you.
All rise.